let's go to fraud or willful breach of trust as a ground to terminate an employee. So if the employee committed fraud, which according to Supreme Court is defined as any act or omission or concealment which involves a breach of legal duty, trust or confidence justly reposed and is injurious to another in the case of Lagay vs. Pacific Concord Container. So any of this act or omission or something that the employee conceals, breaching the legal duty, then it created damage to the employer, then it is considered fraud. So if this is committed by the employee, then the employer will lose the trust and confidence. However, for the element of loss of trust and confidence, we have to look at the requisites. In the case of Charles Ramos versus Court of Appeals, June 29, 2004. You have to remember that the loss of confidence must not be simulated. It must not be used as a subterfuge for causes which are illegal, improper, and unjustified. Third, it must not be arbitrarily asserted in the face of overwhelming evidence to the contrary. Fourth, it must be genuine, not a mere afterthought to justify earlier action taken in bad faith. And finally, fifth, the employee involved holds the position of trust and confidence. Now, these requisites are from the point of view of the employer. These are the requirements on the part of the employer. If you look at the case of Ramos versus Court of Appeals, we have also to complement this on the side of the employee in the case of Lagahit versus Pacific Concord, where the Supreme Court said that from the point of view of the employee, the elements are as follows. The act of the employee must not be ordinary, but willful breach of trust. And second, it must be work-related as to expose the employee as unfit to continue working. So by looking at this case, we really have to include these as requirements in order to justify termination of employment based on fraud or willful breach of trust. The first 5 requisites are from the point of view of the employer, and the second 2 requisites are from the point of view of the employee. And when can we say that the employee's position is vested with trust and confidence? Normally, the following are the different positions vested with trust and confidence. 1. Managerial employees, supervisory employees. Then you have confidential employees, personal secretaries, and rank and file employees that are vested with trust and confidence, like cashier, property custodian, when they are vested with trust with the employer as to its property or its money. So if you abuse the trust, then it is a ground for termination of employment. However, there are 2 different standards when you terminate an employee who is managerial based on loss of trust and confidence. In the case of Supre Multi-Services Incorporated et al. Versus Labitigan et al. August 3, 2016, the Supreme Court made a distinction that if you want to terminate the managerial employee based on loss of trust and confidence, it is enough that there is the existence of the basis for believing that the employee has breached the trust reposed on her or him. However, in the case of rank and file employee, the employer must prove that the employee was involved in the alleged events which led to loss of trust and confidence. So using these two distinctions, it is a little bit difficult to terminate a rank and file employee vested with trust and confidence than a managerial employee. As compared to the old ruling of PLDT versus Tolentino, where according to the Supreme Court, a managerial employee cannot be terminated without any basis. There has been a relaxation now with the recent ruling that the mere belief of the existence of the basis could be a ground to terminate a managerial employee based on loss of trust and confidence. So if you'll be confronted with a situation in a bar examination when you are asked of two kinds of employees who are terminated based on loss of trust and confidence, then you have to distinguish which one is managerial, which one is rank and file. And you know now what is the standard. So before terminating an employee under fraud or willful breach of trust leading to loss of trust and confidence, the employer may also place the employee under preventive suspension if the presence of the employee poses serious or imminent threat to the life or property of the employer, of his immediate members of the family, or authorized representative. While the investigation is pending, to give the employee ample opportunity to explain despite an overwhelming evidence that the employee has committed fraud. Misappropriating the money of the employer by the cashier is considered fraud. So it is a ground to terminate employment. So again, you have to remember that for purposes of terminating the employee based on loss of trust and confidence, the act of the employee leading to breach of trust must be willful. Because if the act was a result of simple negligence, that should not be a ground to terminate the employee based on loss of trust and confidence. The employee did not intentionally do it in order to prejudice or damage or cause damage to the employer.